Hey everybody, it's Paul Yokobitis from Cary Estate Planning back for another video as part of our 366-day challenge. And today I want to talk about the perils of utilizing online templates for your wills or estate planning needs. I met with a family earlier this week whose daughter passed away unexpectedly, and prior to passing, created a will through LawDepot.com. And LawDepot has a plethora of different legal templates that you can purchase or download for free. And you essentially, it's like most legal templates, you kind of fill in the blanks and you sign it and you're on your way, and you don't really understand why they're structured that way, what the provisions of the template actually do, what you might be leaving out, or if the execution formalities are appropriate. So for this will, she actually had it signed and witnessed and notarized appropriately. So the execution formalities comply with North Carolina law, which is surprising because that's usually the lacking aspect of DIY planning through like LegalZoom and Rocket Lawyer and those sort of things. But the issue with this will was a few points. So first, there was a residuary clause in the will, and that's the what we call like the everything else clause. Usually if there aren't specific gifts being made or lump sum, gifts of cash being made, or if you're not specifically calling out assets to go to specific people, everything falls to the residuary clause. And usually our residuary is going to say something like, to my kids in equal shares, all of my property, whether it be real, tangible, intangible, or otherwise, go to certain people in certain shares, right? So this template had a residuary clause, but the deceased did not fill it out. So it had blanks in it. It said, to blank, and but there were other specific gifts being made. And then there was what was called a wipeout provision or a wipeout clause, which is kind of distasteful, first and foremost, because it basically contemplates everyone else in the plan predeceasing you. But it's usually what we would call a contingent remainder beneficiary clause. That portion had a provision that gave, it basically split the estate into 100 shares, and it gave 50 of those shares, or one half, to the brother-in-law, and it gave the other 50 shares, or the other half, to a church, right? So it divided the estate into 100 shares and then gave 50 shares to one and 50 shares to the other. Not needed. I mean, you can do half and half, right? One share each, 2 shares. But so what this created is a legal issue, right? There is no residuary clause, or at least not a sufficiently valid residuary clause, but there is a contingent remainder clause that names 2 people that are not the parents or the sister. So the clerk of court, when they received this will, basically doesn't know what to do with it. So they've instructed the family to institute what's called a declaratory judgment action, which is basically filing a lawsuit and asking a judge in the county to basically interpret this will and determine who is supposed to get what, whether that residuary clause being vacant or blank makes that portion of the estate subject to intestacy, or whether that wipeout provision becomes the new residuary clause. Certainly unintended consequences, right? So this is a pretty extreme example, but it's not uncommon, for these sorts of errors to pop up in DIY planning. So this is why we use lawyers. It's not, just to pay more in fees. You're paying for experience and strategy and know-how. And so that stuff like this doesn't happen, because this family is going to end up paying significantly more to institute this declaratory judgment action than they would have ever paid than the deceased would have ever paid with appropriate legal planning. This will, had it been created by a lawyer and it lacked these types of provisions, that would have been legal malpractice. So it should have never happened to begin with. It potentially would have been better had she not had a will at all, unfortunately. But that's the reality, right? So when you plan yourself, it's subject to whatever sort of lack of education or lack of understanding or potential issues that may come with that. It's just like trying to do your own roof replacement. If you don't know what you're doing, it's probably not going to go well, and you're going to end up having a big water leak and much more damage than you would have spent to actually do it right the first time. So keep that in mind. Obviously, failing to plan is planning to fail generally, but sometimes it's just a better idea to work with professionals to do this for a living, and have seen the good and the bad, and learn from that, and created strategies to avoid the bad. If you have any questions about your planning needs, go ahead and click the link below, and you can get on our calendar to sit down and speak with me directly and talk about what planning is right for you, what that should look like. Otherwise, look out for more videos this week, and I hope you enjoy the rest of your week. This is Paul from Cary Estate Planning.